Well, good morning, everyone. Enid wasn't joking when she says the hall is full. This is, as Enid said, our fifth compliance conference, and we've certainly managed to bolster the numbers. So I'm actually very heartened that so many of you felt that it was worthwhile coming here today. From our perspective, obviously, it gives us this wonderful opportunity to be on broadcast mode and to actually talk to you about the types of things that have been happening at the SRA and many of the things that Enid's already mentioned. But I think much more importantly, it does give you the opportunity to contribute to our agenda and to actually make us aware of what you think of what we are doing. What do you like? What do you not like? What would you like to see more of? What would you like to see less of? Because of that discussion, we will be a better regulator. So although it's a good opportunity for us to actually stand here and tell you what's been happening, it's a much better opportunity for us to hear what you think of what we are doing in the margins of today over tea, coffee or lunch. So please don't be shy, I'm sure you won't be, and feel free to come forward and speak to any of our board members, or there's quite a number of senior staff here, I'm sure you'll know who they are. So what I'd like to do in the next 20 minutes very much is just to take you through what's going to be happening at the SRA in the next few years. So last week, the SRA board signed off our new 3-year corporate strategy, taking us from 2017 through to 2020. And that corporate strategy has 5 corporate aims, and I wanted to take you through just what those are and some of the work programs that actually lie beneath them. But before I do that, I wanted to just pause and think a little bit about the distance travelled. So, as Enid said, 5 years ago, we kicked off this conference with about 100 people or so. Today, we have 1,400 people registered for the event, and even with a few drop-offs, I hazard a guess that there's well over 1,000 in the room right now. So we have actually grown in terms of our organisation, and we've done a number of things. And just to trot through some of those things, I think many of you, if you were around 4 or 5 years ago, and I hazard a guess you were, then you will remember that we started operationally from a fairly low baseline. Many of you will remember the implementation of my SRA. Many of you will remember the practicing certificate fee renewal exercise that year. It was a bit of a debacle. And although that was a low baseline, and I think that's probably, hopefully, fingers crossed, the worst that we get, we have actually come from strength to strength over the last 4 years. And if you look at our operational work, if you look at things like our authorisation work or our disciplinary work or our client protection work, or even the performance of our contact centre, for those of you who perhaps contacted over the last few weeks on PCRA, I think you would agree that we're much quicker, we're making better decisions, and our levels of customer care are better. I'm not suggesting for a second that we couldn't do more. We can. And I'll come back to that a bit later. But there's no doubt in my mind that operationally the organisation is far more fit for purpose than it was 4 or 5 years ago. And if you look at our policy journey, we've been no slouch in terms of looking at the regulatory model and looking at the educational model in terms of policy. And in terms of educational policy, we moved very quickly out the traps after the Legal Education and Training Review to look at CPD and abolishing the idea of collecting points for CPD, whilst at the same time maintaining front and centre the obligation, your obligation, to be up to date and to be fit to practice law. We moved very quickly on to publishing a competency statement for the first time in history of what it means to be a practicing solicitor. And then straight into equivalent means and looking at the SILEX route to entry to the profession and looking at apprenticeships. And I'm very pleased to say that a number of firms have taken up that cudgel and actually are employing more and more apprentices each month. And actually, from our perspective, that can only be a good thing. And it's an interesting segue into the next panel session where we'll be talking about the Solicitor's Qualifying Examination, a national licensing assessment that will actually help us maintain the high professional standards that the public has a right to expect of solicitors, whilst at the same time deal with some of the consistency issues that I honestly believe that are present in the present arrangement. So from an educational policy perspective, we've done a lot. From a regulatory policy perspective, we've shifted the whole focus of the organisation away from a compliance management focus towards a professional regulator model. And we did that through taking, again, the cudgel on ABSs, looking at how they can work better, changing our multidisciplinary practice rules to make sure that other people can own legal businesses, and importantly, to make sure that, that accountants can own solicitor businesses. We then needed to even up the playing field by more or less abolishing the separate business rule to make sure that you, as traditional solicitors firms, could own other types of businesses. And then we've changed the accounts rules, we've simplified the accounts rules, we've reduced the bureaucracy at the SRA, and to a certain extent, much of the regulation. And all of that was a move away from the previous direction of travel of the SRA, which was a compliance financial services focus, much more towards recognising that solicitors are professional people and they need to be treated as professional people, and actually trust is the core issue that lies at the heart of that. And in many ways that's why we did the question of trust exercise, and if many were here at this event a couple of years ago, you will have heard Crispin Passmore take you through some of that exercise and looking at what it means from an ethics perspective, what it means from a rules perspective when you breach those rules, when you derogate from our handbook, and what should happen. So it was ethics in context or ethics in practice. And we did a huge exercise. We touched something like about 6,000 to 8,000 solicitors during that whole process, which took about 9 months. And much of that learning we will roll over into our enforcement strategy, which I'll talk a little bit about later. So that's the what we've been doing. And I suppose I just wanted to mention really the why we're doing it before I talk about our corporate strategy. And the reason why we're doing this is because we fully believe that the SRA should and is a public interest regulator. We have the public interest and the wider public interest at our heart. We regulate very much to bolster confidence in the solicitor's profession. And I suspect here we do have common purpose as the regulator and the regulated. We definitely have common purpose because from my perspective it's very much in the public interest that the public can and do trust solicitors. You wouldn't be able to do business otherwise, but it's obviously in the interests of solicitors that the public trust them. So I do think we have common purpose as a regulator and those that we regulate to make sure that we bolster public confidence in solicitors. The Law Society might say bolster the Law Society, bolster the solicitor's brand, and actually I have nothing against that. We are about bolstering the solicitor's brand. We just call it public confidence because if you don't have public confidence, you have no brand. So that's why we're here, and I just wanted to make the plea to say that I do think we have commonality of purpose. I think perhaps where we start to get into disagreement is that one of the other issues that we're here to do is to act in the wider public interest. And we firmly believe that it's in the wider public interest that there is a vibrant, strong, dynamic and competitive legal services market. That type of market allows many opportunities for people like yourselves to contribute to that market, to get larger market share and hopefully become more profitable businesses. But it also drives down the price of legal services, and it, in principle, allows more people to access legal services as a consequence. So that's the reason why we're here. That's what we have done so far in the last few years. And I'm just going to trot through a few slides now that will take you through what the board agreed last week in relation to the corporate strategy, which we will publish in about 2 weeks' time. And those 5 key priorities that we have, and all of those 5 key priorities are underpinned by the issues on that slide. So, maintaining and promoting high professional standards, the need for regulation to work for all types of firm or all types of business. So the legal services market is pretty vast these days, and I have been on platforms over the years pointing out that in my personal opinion there isn't such a thing as a legal services market. There's a number of legal services markets. If you were practicing in criminal law in Liverpool, then your experience would be very, very different if you were practicing commercial or corporate law in the City of London. And therefore, actually, we need to be alive to that and make sure that we tailor our regulatory model accordingly. For instance, about 5 years ago, We changed our overseas practice rules in order to deal with an issue that large global firms were having with lots of their fee earners being regulated by us, but actually being based in places like Hong Kong or Singapore. Alternatively, we launched about a year to 18 months ago the SRA Innovate website and the SRA Innovate helpline to actually help new entrants to the market, or to help people who are in the market actually make sure that they are compliant with our rules and our regulations when they're developing novel or innovative approaches. More recently, we issued a toolkit for advocacy in the youth court, and we've done a ton of work in relation to trying to help sole practitioners and small businesses actually basically weather the storms of the marketplace, and you can see most of that on our website. And all of those really are an attempt to make sure that regulation is tailored a little bit to meet the circumstances within which you practice. And then lastly, perhaps the area where it can be a bit more contentious is this idea of balancing a healthy, open, competitive marketplace with appropriate levels of consumer protection. And actually that can be quite tricky, and we would argue that proportionate regulation provides appropriate consumer protection, and there are places in our regulatory model where we gold plate it, and that gold plating builds in regulatory cost and regulatory burden, and you have no option then but to pass that on to your clients. If we have a price-competitive legal services market, then actually that cost you will take out the business and pass it on to clients. And that is the theory that we're trying to achieve in relation to that work programme. So moving quickly on, Strategic Aim 1, we will set and apply consistently high professional standards for the individuals and firms that we regulate and make sure that they are appropriate to meet the challenges of today and the future. I've already mentioned one of the key work programmes under the strategic aim, and that is the Solicitors Qualifying Examination. I'm not going to go into any detail here. We'll have a whole session on it a bit later. But the idea of the SQE is about maintaining and promoting high professional standards for those who enter the profession, to make sure that those are the types of people who will have public confidence and who will protect the brand of solicitor. That's first and foremost what it's about. Secondly, it's about maintaining consistency, because there are a number of different providers of courses on the present arrangements, and we wanted to make sure that we have a credible assessment provider who would actually set the assessment, and regardless of what mode of entry to the profession you use, be it a traditional law degree, a science degree in the GDL, or an apprenticeship, you will sit exactly the same assessment as everyone else, and that's the fundamental principle behind it. Also, under this strategic aim, we consulted on new codes of conduct about a year ago in our first Looking to the Future consultation. We'll have a code of conduct for law firms, code of conduct for solicitors. We will remove the ambiguity of you the solicitor, you the firm, you the business owner, and hopefully it certainly was well received, and we think that will work well in future. I mentioned the new enforcement strategy a bit earlier on. So our present consultation on Looking to the Future has as a key component our new enforcement strategy. That's taking all of the work, all of the learning from the question of trust exercise we did a couple of years ago, and feeding that into a principle-based enforcement strategy, looking at how we should take action in relation to any particular derogation or breach of our ethical rules in relation to any particular context. And I do commend it to you. I think it's worthwhile reading. It will impact on you, and it will impact on your firms in the months and years ahead. And lastly, in relation to this strategic aim, we have the idea of the profession reflecting the community it serves. In relation to how we address that type of thing, most of what the regulator does is to shine a light. And one of the things we are doing today is we are publishing an independent qualitative research report from Leeds University on changing demographics in the profession since the 1970s, an absolutely fascinating piece of work which tells the story. It tells the story of increasing diversity, but also of hardship, also of difficulty, and it's worthwhile reading. Together, we're also publishing our own work on what we see as best practice in the marketplace, the types of things that law firms are doing on equality and diversity that we think is really, really good. And both of those reports are available at our stand in the concourse where you had coffee this morning. I do recommend it to you. Please do take hard copy before you leave today. Failing that, you'll be able to get them on our website in the next week. But that's the type of thing in relation to strategic aim 1 that we're doing in terms of equality and diversity. The second of the 5 aims is that we will work to make sure that our regulatory requirements are proportionate, providing firms and solicitors with the flexibility to innovate and better meet the needs of members of the public and businesses whilst maintaining appropriate levels of public protection. I've already talked a bit about proportionality, about how you get a proportionate model, about how a disproportionate model actually feeds costs into the system that you inevitably have to pass on to clients. So that's really what proportionality is about. At the same time, it's about having proportionate levels of consumer protection in the solicitor's model. And if you have disproportionate levels of consumer protection, you have gold-plated consumer protection, then you will pass that on to clients, and that will add to costs, and therefore it will add to people even being less or more reluctant to actually seek the advice of a solicitor. Our own research suggests that 9 out of 10 people who have a problem, a legal problem, do not access a bona fide, properly trained solicitor, and we think that's an issue. And that's one of the primary reasons why in our first Looking to the Future consultation last year, we had what I think many people think is quite a contentious proposition, and that is that a solicitor in future should be able to operate as a solicitor outside of an authorised firm. And the idea of that is to bring solicitors close to the public, to allow greater access to a properly trained, properly regulated solicitor. But there is no doubt that the level of consumer protection that person gets at that point in time will be reduced. And it's a trade-off. It's about trying to be proportionate, and we think that's the right way to go, and we're going to have a go at doing that in the years ahead. So the way in which we do it is generally through reviewing our handbook. I'm pleased to say that, and I can't remember the actual numbers, I think the handbook's about 470 odd pages long. So if anybody's read it, then I think you're probably a rarity. What we actually want to do is to reduce it, and we're reducing it to a number which I can't remember off the top of my head, but it's certainly probably double digits rather than triple digits. And that reduction in bureaucracy at the same time as moving to a principle-based approach, we think will reduce regulatory burden. And lastly, I've already mentioned SRA Innovate. It's a service that's on our website. You can ring us up if you have any novel, new or innovative ideas as to how you want to develop your firm or how you want to bring a new firm to the marketplace. Then we would be really keen to talk to you and really keen to see if we can facilitate that happening, because we're keen on a competitive legal services marketplace, and we think that's important. So moving on to 3 of 5, we will increase the availability of relevant and timely information to help people make informed choices in the legal services market. So many of you will already know that round about late 2015, when Michael Gove was Lord Chancellor, he announced a review by the CMA of the legal services marketplace, a preliminary investigation, as the CMA calls it, and they reported in December of 2016. And since then, we have been working with them and have just published a consultation which is extant at the moment on what I might call consumerism, open data, the types of things that we think will drive a legal services marketplace. Now, the CMA said it felt that the legal services marketplace was not working correctly, and its panacea for that was more information for consumers. So if you look at our consultation, which is live, and you can get it on our website, you will see the types of things that are on the slide. What we are proposing is something that most lay people, I think, would think is already there, and that is a regulatory register, a register on the SRA's website that says who you are, where you're qualified, what you're qualified to do, and any disciplinary findings which are extant, and potentially any disciplinary history within the protections afforded to you by the Data Protection Act. And those are the types of things that we think, if you were a layperson who was using a solicitor for a rare opportunity during your life, you might be interested in knowing before you actually chose Solicitor A over Solicitor B. But going a little bit further in terms of nudge theory, what types of things would a person, a member of the public, a mythical consumer, actually be looking at before they chose a particular law firm? Well, they might look at complaints. How many complaints does this law firm have? How many of them were legitimate or upheld? How many did the regulator receive about, Snooks and Co? How many were upheld? Those are the types of things that we're thinking about obliging law firms to publish, and we're thinking about publishing ourselves. I do realise that some of that is contentious, and that's why I encourage you to look at the consultation and to respond to the propositions that are contained therein. And lastly on this, and perhaps the most contentious point, is price. Price comparison websites are everywhere. They're not everybody's cup of tea, but I think it's generally considered that actually from a consumerist perspective, they provide a valuable service. And we think that actually in future solicitors should publish price data, and we're only trying to figure out how best it's done, because we all know that hourly rates don't really tell you very much. But in some transactional types of legal services, conveyancing being the obvious one, more and more you see single prices for the single job. And all of that is contained in our present consultation. I do encourage you to have a read at it. It's probably one of the most important things we're doing in the next couple of years. And the outcome of that consultation will influence us quite significantly in how we take this forward in the months and years ahead. So the penultimate aim, strategic aim 4, it's a bit wordy, but it says we will make sure that our regulatory arrangements work as effectively as possible for the public, businesses, solicitors and firms in the context of constitutional developments within the UK and the EU. I think as a quasi-public services or public sector regulator, we would be remiss not to have Brexit front and centre on our agenda. It's one of those horizon scanning issues. It's happening to everybody, and it will have implications for everybody, but it will certainly have implications for us, and it will have implications for you. And we are certainly plugged in, and we're dealing with the various national bodies in terms of trying to understand what's happening. The bad news is until the government sorts out its position on hard, soft-boiled Brexits, etc., then actually we don't really understand what the implications would be. But I suspect from the legal services perspective, it's the same as everywhere else. Access to markets, particularly markets in Europe, free movement of people routine here in Europe, particularly people who are members of staff that work for organisations like yours, and making sure that there's a degree of reciprocity in terms of professional qualifications and professional experience. So we've got a watching eye on Brexit. There's not a lot more I can say. I think working with Wales, it's not just because Enid Rowlands happens to be Welsh that we're interested in Wales. Wales we're a two-country regulator. We regulate in England and we regulate in Wales. And up until about 10 or 15 years ago, that didn't really matter. But with the inception of the Welsh Parliament and the level of legislation that's coming out of the Welsh Parliament, we're seeing a very distinct Welsh jurisdiction emerging. And for a regulator to be effective, it has to be relevant. So we need to pay close attention to what's happening in Wales and what the legal developments are in Wales, and make sure that we are fit for purpose for businesses, for legal businesses and individual solicitors that are based in Wales. And that will be, again, front and centre on an agenda moving forward. The next two bullet points, I'm afraid, are a plague on all our houses. They are essentially an issue for you, and they're certainly an issue for the SRA and for me. Next year, we will have the Financial Action Task Force visit from Brussels. They will pay close attention to the legal sector because they believe that law firms are enablers of money laundering, and therefore they will be looking very closely at the regulatory arrangements that we have, and they will be paying a lot of attention to the profession. So money laundering is a big deal for us. We have a big visit from Europe coming up next year, but also we have a raft of European regulations that we have to deal with, most notably the development of a separate regulator within the FSA. They look at money laundering, who will end up being our regulator as well as your regulator. And then we have the General Data Protection Regulation and enhancement of the Data Protection Act. For any organisation, be they large or small, that has personal data, this is something that has to be on their agenda, and it's certainly on ours. And lastly, strategic aim 5, we will work better together and with others to improve the overall efficiency, responsiveness, effectiveness of the organisation in delivering what we do, that is regulation. And I started off by saying that I think we have a good story to tell in terms of the improvement, the operational improvement within the organisation, and I think we do. But I have no doubt that there's no room for complacency. We know that we are spending your money and we need to do so in a competent way. And I can say that in the 4 years that I've been at the organisation, I have reduced the SRA's operating budget every single year. And if you compound that effect over the last 4 years, there's something like a 15 to 20% reduction in the operating budget of the Solicitors Regulation Authority. But that doesn't mean that we can't do more. And if you look at our continuous improvement work, and importantly, if you look at our IT, modernising IT programme, you will see many opportunities for reducing the central cost of regulation more. What you will see if you read the Law Society Gazette is that both the Society and the SRA are spending quite an eye-watering amount of money on IT. That's because there's been no money spent on IT for some considerable time, and therefore we're playing catch-up. We need to play catch-up in order to make sure that your personal data and all the money that you give to us is kept safe, because we face as many challenges on cybercrime as you do, and to make sure that we have fit-for-purpose modern infrastructure that will make us a modern organisation that is worthy of the solicitor's profession. So those are the 5 strategic aims. That whole strategy goes between 2017 and 2020. And those are the types of work programmes that are contained therein and that you will hear more of from the SRA over the next 3 years. So with that, I'm going to stop talking now. I hope you enjoy the rest of the day. As Enid said, please do take the opportunity to come and speak to us. It is through that dialogue that makes us a better regulator, and hopefully we will be able to take quite a lot of that on board and shape a regulatory model as we move forward. So thank you very much for listening, and Clive, back over to you.